can I include my children in this application? Many parents make the false assumption that just because their children live under their roof and are studying perhaps, that they can be included. There's some very, very crucial rules that exist. Let's start with a simple rule. Under 18 years old. Under Australian migration law, if a child is under the age of 18, they're automatically included as a dependent in your application, so long as they are single. So in other words, they're not married or engaged to be married or in a de facto relationship. Depending on your circumstances, you may need to demonstrate that you have legal custody of those children or that you have the consent for that child to migrate with you. So the next bracket that I'm going to talk about is from the age of 18 up until the age of 23. And by that I mean before their 23rd birthday. For most skilled and employer-sponsored visas, so for example, the subclass 186, the subclass 189, the subclass 190, children above the age of 18 but younger than the age of 23 can be included as a dependent in your application. Once the child turns 18, you must demonstrate that they are wholly or substantially financially dependent upon you for their basic living needs. In most situations, a child over the age of 18 but under the age of 23 must also be studying full-time, or by that, not working full-time. In addition to proving this substantial financial dependency, a child must be single. So they cannot be married, engaged to be married, or in a de facto relationship with another person. Now, this is a really important difference for the subclass 500, which is the student visa. If you have a child who's above the age of 18, they must apply for their own student visa, or if they're not going to study, a visitor visa. They cannot be included as a dependent on your own student visa application. Under Australian law, once the child turns the age of 23, they cannot be included as a dependent in your application. There is one extremely rare set of circumstances where they could be, and that is if your child has a significant physical or intellectual impairment and they are solely reliant on you to provide care to them. That is the only exception to the 23-year-old age rule. Once your application is being processed, if your child turns 23 during that processing period, then the department will not consider them to be your dependent when they come to make the decision. That means that you and the rest of your family may be visaed, but your 23-year-old child will not receive the visa with you. If you've got a child above the age of 18 but under the age of 23, you must lodge your applications to ensure that the visa process is completed before they turn 23. I cannot stress this enough. Do not leave things too late. Contact us here at Pathway to Oz. Speak to one of our highly experienced and professional migration agent team. Click in the description below to book a consultation with our migration team. And please make sure that you like this video and subscribe to our weekly updates.